Good afternoon, everyone. My name is Madhusudan Sarma, and I welcome you all to this 11th lecture of N100 series. In this series, we are discussing polity theme-wise from the mains perspective. Every theme, we go into the detail of what, why, so what, way forward, arguments in favor, argument in against, all those dimensions that may be asked in a mains question. Okay, so let's start today's class. We have already had one lecture on legislature. In case you missed it, you may go back to the playlist on our Narayana IAS Academy YouTube channel and watch that lecture. Right now, let's continue with the second lecture, and we shall start from where we had left the last class. In the last class, we have looked into the money bill, financial bill, etc. So we shall start from the one aspect that we had left in the last class. Then we will move to anti-defection law, the role of the presiding officers, how it is in debate these days. And then in the last, we shall also see this class, how is state legislative council a secondary chamber, not a second chamber like Rajya Sabha. Okay, so let's start today's class. Good afternoon, Yogesh. The first thing first that we have to answer is, this is something that we had seen in the last class, budget related provision. What are the different stages in budget? Like there is presentation of budget followed by general discussion, scrutiny by departmentally related standing committees, then voting on demands for grants, passing of appropriation bill, and then passing of finance bill. This is something that you should keep in mind, that first appropriation bill deals with expenditure. First appropriation bill is passed, followed by finance bill. Finance bill deals with income of the government. Now see, this is the difference between the way government makes its budget and the way we normal people, the citizens, make our budget. See, you might also have made your budget, prepared your budget, and in that preparation, what you do? First of all, you calculate your income. You see how much is your salary, etc. What are the different sources of income? After that, as per your salary or the saving, you decide what is going to be your expenditure. But the government does it opposite. The government first looks after its expenditure. How much is the money that it has to spend? And then accordingly it varies the taxation provision or the borrowing that it has to do from the market, the interest on which it has to pay the interest, also the fiscal deficit, etc. So this is the fundamental difference between the budgeting by we individuals and the government. Yeah, I mean, this will help you remember the fact that first appropriation bill is passed, then finance bill is passed. We have also seen how finance bill is different from financial bill. Financial bill as such is a umbrella terms which denote all the bills that have financial matters. And in our constitution, we have specifically mentioned financial bill for two type of bills. One where money bill, the items related to money bill are mentioned along with some other items. Okay, and another is where the some expenditure is involved from the consolidated fund of India. So that was the financial bill 1 and 2, two types of financial bill that we have seen. Okay. Then we have seen vote on account and interim budget. Do you remember the difference between vote on account and interim budget? Anyone? Please reply. So it's very simple. I will tell you. Vote on account. Okay. Vote on account. First and foremost thing, vote on account is mentioned in our constitution. It is there in article 116. So see, all the matters related to how the budget etc. would be passed. Budget is there in 112. In 116 we have vote on account. Good afternoon, Manoj. So what is vote on account? Vote on account is that, see, when budget is presented, or earlier used to be presented in the month of February, there was only 1 month left between the presentation of budget and the beginning of the next financial year. And as soon as the financial year begins, some expenditure has to be done by the government. Government has to run its machinery. There are so many employees, salary has to be paid. There are so many contract workers, etc. Everything is there. So because budget is not passed by 1st of April when financial year begins, in the meantime, when budget is passed and beginning of financial year, so from 1st of April to the date when budget is passed, I mean maybe passed on 30th of April, maybe passed on say 30th of May, the government needs money to do its expenditure for its expenses. So the money provided for expenditure between 1st of April to the passing of the budget, in this period, whatever the money which is given to the government, this money is called vote on account. So it only has the element of expenditure, and it is not for the full financial year, rather for the period till budget is passed. Okay. Yogesh, you understand the concept, but the word that you have used, publication of budget, is not appropriate. It is the passing of budget, or you can use the word approval of budget by parliament. Next is, what is interim budget? So interim budget is as such not mentioned in constitution. It is an informal term that has come to be used. Formally, it is neither mentioned in the rules of the Lok Sabha or Rajya Sabha, neither it is mentioned in constitution. So nowhere it is formally mentioned. It has come to be used informally. And informally, when do we use? So a government which is not supposed to last full finance year. So a budget presented by a government that is not expected to last full financial year. Usually in an election year it happens, because the government knows that our term is going to be completed before the end of the financial year. So the budget presented by such a government is called interim budget. Okay. So a budget presented by government whose term will end before the financial year. So in that case, the convention has developed that when a new government will take charge after the election, that government will present the full budget, which is called normal budget. And for the interim period, an interim budget should be presented. However, it would be a wrong statement to say that interim budget has only provisions for interim period. That is not correct. I am repeating it again. It would be wrong to say that the interim budget has provisions only for the interim period. And a lot many newspaper article also you will see from the prominent uh, media houses which had made this mistake. If you simply go and look at the interim budget which was presented this year on 1st of February, it had projections for the full financial year. Okay? So it has first both income and expenditure, and the projection for income for the full financial year. Okay. Why it is being called interim? Because it is going to be overridden by a new budget when a new government takes charge. I repeat, it is called interim only because it is going to be, or it is expected to be, overridden by a new budget post-election or a new budget when a new government takes charge. But suppose it so happens that no party gets majority. There is a hung Lok Sabha. In that case, probably there is going to be no new government. Maybe there could be another election after 6 months. So, whatever was the interim budget, that interim budget would act like the budget for the whole financial year. Okay, so as such, the projections of the income, expenditure, all the data, etc., allocations for the ministries are done for the whole financial year. But when the new government comes, it passes the new budget, and that new budget overrides the interim budget. That's the clarity. Is it clear? Any doubt? Can government continue with the interim budget if same government wins? Yes, it can. But usually in election you go, you make various promises, etc. So to implement those promises, or like after the election you want to you want to give a message to the people. So that's why there is a convention that when a new government comes, many a times it so happens that a new finance minister also comes. Many a times it so happens that like new prime minister comes. A lot many new ministries takes charge. So because of that, then invariably the new mind is applied, and invariably some changes are to be done. Okay, and by convention it has also developed, again this is also by convention, that no major, this is something you will be see, you can see in various newspaper articles, etc., that by convention, I would not write to I would not ask you to write no, rather many major announcements are not done. Announcements or changes are not done in interim budget. But again, a lot many newspaper article you will see where they write no major announcements are done. That is also not correct, because see, schemes like PM Kisan Yojana, they were announced in the interim budget of 2019. That was a major scheme. So it is completely up to the finance minister who is presenting the budget, or the government who is presenting the budget, what announcement it wants to take or not take. As I have said you, it is an informal term. There is no mention of any regular any part in the constitution or rules. So as such, there is no limitation on the government. The government is limited by the thing that it decides to limit itself. Statutorily there is no limitation on the government. So that's why we should write many major announcement and changes are not done normally by convention, but there has been time and again such announcements have been done. Okay, like in 2009 interim budget, the agriculture loan of the uh, farmers were waived off. That was a major announcement. Similarly, in 2019, PM Kisan Yojana was announced, major announcement. So there have been some major announcement that has been done time and again. There is no restriction, but yes, finance minister decides to not do a lot many changes in interim budget. Okay. Next topic that we are going to see is anti-defection law. You must be knowing it. This is also known as 10th schedule because it is mentioned in the 10th schedule. Which constitution amendment brought this anti-defection law? Anyone? No one remembers it. It is the 52nd Constitution Amendment Act 1985. So 1985 is the year when Rajiv Gandhi was the prime minister. So that was the time when people have got fed up with this. There is something called Aya Ram and Gaya Ram culture, and this was Gaya Ram as such Gaya Ram, he was not Gaya Ram, he was Gaya Lal. Okay, so Gayalal was an MLA in Haryana who happened to switch his political party thrice in a day. In one particular day only, he changed his political party 3 times. And after that, the term became famous, Ayaram Gayaram. So this is the Ayaram Gayaram culture that has that was prominent in Indian what you say democracy. And then Rajiv Gandhi decided that enough is enough. There is a need to restrict this culture. So first of all, we need to understand uh, 2-3 things we shall study. First is like what are the provisions. Second, we shall study what's wrong with anti-defection law. What are the issues that have come up. Okay, and then we shall see what we can do. Okay, so first of all, let's understand what defection is. So defection is simple, changing of party allegiance by elected legislatures. This is only relevant for elected legislatures. So those people like who are the party workers or who lost election. If they change political party, it is not called defection. Okay. So elected legislature is termed as political defection. Now, what are the provisions? Provisions of 10th schedule. So, provisions are different for different kind of electors. Like there are three different kind of electors. One is who has won the election on any party ticket, maybe Congress, BJP, or any other political party. Another, some person also contest election independently and they can win the election as well. Independent candidate. And then there are few people who are nominated. Now they are only in the Rajya Sabha. So the provision says that if a person who is a party member, if he voluntarily gives up the membership of a political party, if he voluntarily gives up the membership of a political party, he would be subject to disqualification. He would be disqualified. So suppose you have contested election on a political party A, but then you give up his membership. Now, when it would be decided that you have voluntarily given up, one thing is like you have done given resignation. If you have resigned, then it have give up the political party. The second thing, you might not resign from your political party, but you join other political party. If you join other political party also, then it will be considered that probably you have left this political party. And the third thing that can happen is you vote contrary to the instructions given by the party, which is called whip. So whatever be the instruction that is issued by the political party, that suppose on a particular bill you have to vote in favor. Suppose a member votes against that bill, it means he has given up the membership of that political party. Now he is taking a stand contrary to the stand of the political party. And suppose you do either of these three things, you would be subject to disqualification. For independent members, since there is no concept of say resignation from political party, there is no concept of voting contrary to the whip because he does not belong to any political party, there cannot be any whip. So for independent member, the only thing that applies is second point, that if he joins any political party. And a nominated member can be a part of any political party. If he is a part of any political party, he is a nominated member, then all of these will apply. If he gives up his political party, resigns or join other political party or vote contrary to the bill. But suppose, or this is most often that happens, like suppose a cricketer is nominated, a singer is nominated, so they usually do not belong to any political party. In that case, they are given a 6 months period to join a political party. Now, see, since they have agreed to be a member of Rajya Sabha, to be an MP, there are chances that probably now they want to pursue their career in politics. So once they are nominated, they can join any political party within 6 months time period. If they do not join any political party in this 6 months time period and they join any political party after that, they would also be subject to disqualification. So they have to decide within 6 months if they want to join any political party. Independent members, since they are already in the politics, they are not given any such 6 months moratorium period. If they join any political party, they would be subject to disqualification. For those who are already a party members, if they resign or they vote against the whip, they would be subject to disqualification. Next thing is, who will decide? See, it might be the case that you know all these provisions, but systematically, if you do the revision, because see, if a question comes, you have to write all the points as well. Yes, so ultimately, if there is no automatic disqualification. What do I mean by this? I simply mean that suppose it so happens that a person has resigned from his political party. It would not mean that he is disqualified from the next day. Someone, I mean that political party, would have to file a petition to the speaker, and on that petition the speaker will decide if that person is subject to disqualification or not, or in case he is a Rajya Sabha member, the chairman of Rajya Sabha. So rather the more appropriate word is the presiding officer. The presiding officer of the house will decide if someone has become subject to disqualification or not. Then there are a few exemptions that have been given, exceptions are there. Originally, when the act was brought in 1985, it has given two grounds of exception. One is when there is a split in the political party. Sometimes it may happen that, see, political parties, not all MLAs are agreeing to the views given by the party president. Okay, so like party president is saying that we should oppose the farm bills, but or rather support the farm bills, but maybe that MPs from Punjab or Haryana, they might have the view that we should oppose the farm bills. In that case, if these party members who have a different viewpoint, they consisted one third of the total strength in the house, that would be called a split. An original act allowed a split that one third member, they can get out of the political parties and they would not be subject to disqualification. Merger is when two-thirds of the legislature in the house, when they decide to join other political party. So here there has to be two things. First is the number of MPs or MLAs deciding to quit the political party. There should be at least two-thirds. So suppose there are 30 members, 30 MPs are there for any political party, at least 20 must leave the political party. And second, they cannot form a new political party. It has to be a merger with another political party. They cannot form a new political party. They must join some other political party. Okay, that would be called merger. In case of a split, the limit was one third and they could have formed a new political party. But this provision of a split was deleted by 91st Amendment Act. Okay, so now we are not studying that. Simply you are studying that now a split is no more an exception. Okay, then presiding officers, they are exempted from disqualification. Why? Because see, it is expected that presiding officer will maintain neutrality. He may decide not to be a party member, because see, he is the like speaker of the Lok Sabha. So for him all political parties are equal. Now he is the first person or the head of the house. So to maintain his neutrality, he may decide that now he will not be a party member, he will resign from his political party. So because of that peculiarity with the position of the speaker or deputy speaker, chairman or deputy chairman, they are exempted that even if they resign from their political party, or even if like after they meet the office of a speaker, they might join back their political party, they would not be subject to disqualification. Okay, there is a doubt, I will take it. If you have any other doubt, you may also ask that. Sir, presiding officer includes deputy speaker and vice president. Yes, even deputy speaker, vice president, and vice chairman. All these four people, they all of these are included in presiding officer, and they are exempted in both the times. First, when they are elected as the presiding officer. Sometimes it may also happen that after that they decide to resign from the office of a speaker, or maybe they are removed from the office of speaker. So they can join back their political party as well. So at both these instances, they are exempted from disqualification. Is it clear, Manoj? Now, 91st Amendment further added, first thing that 91st Amendment did is removal of a split as exemptions. Exemption or exception, whatever you may write. The second thing that 91st Constitution Amendment did was, see, most of the time the lure for defection was given that if you come to my political party, I will make you a minister. In that political party, you are the common MLA or MP. So obviously, if I am getting a ministry, I will like to change my side. So the lure of ministry was the biggest lure which was given to the MPs and MLAs. So it was decided that we need to limit the number of ministries, because it was also having another side effect, that suppose a lot many the ministry or the size of council of ministers is large, it will have burden on public exchequer. Ultimately, they will have to be provided bungalow, vehicles, salary, etc., secretarial staff. So this was creating burden on exchequer also. So that's why it was decided that the maximum strength of council of minister is going to be 15% of strength of lower house. So in case of Lok Sabha, 15% of 543. Suppose there is a state legislative assembly which has 300 members. So 15% of 300. It is not the 15% of the strength of the party forming the government. It is not dependent on that. The political party may win, so for example, a political party may win 300 out of 300 seats. Still the limit would be 15% of 300, that is 45. Or in one case there could be that a political party is having only 151 seats out of 300. Then also it can make 45 ministers. That is the maximum limit, 15% of strength of lower house. I am saying because same anti-defection law, whatever provision that I have told you is applicable on a state as well as center. So in case of a state, it would be a state legislative assembly. In case of center, it would be Lok Sabha. Okay, and then it was also said that if a person is disqualified under 10th schedule, he would be disqualified to be a minister. Suppose a person is disqualified in the 10th schedule. Now, this is the normal thing that you might be knowing, that a person can become a minister for 6 months even if he or she is not a MLA or MP. There is a 6-month time period given. In this 6 months time period, he has to become the member of the house, either house. Okay. So it is a possibility that he is disqualified. Still, he is made minister. He will contest election within 6 months, because election commission has to conduct election within 6 months. He can win election and again become the minister. So it was made clear that as soon as you become disqualified in the 10th schedule, you cannot become minister either. Okay, Manoj is asking another question. It is not applicable for Delhi Legislative Assembly. For Delhi Legislative Assembly, it is written that the maximum strength, including Chief Minister, could be 7. So it is mentioned in NCT Act itself. So that's why this provision is not applicable. Anyway, this provision is not applicable for UTs. This provision is applicable for states. UTs are governed by their respective, whatever be their uh, act that provides for their legislature in their respective UT. Okay. Next is, there are some other provisions also, like who is going to be the deciding of authority. It is going to be the presiding officer. Then in this Kihoto Holohan case 1993, it was this whole constitution, 10th schedule itself was questioned in Supreme Court on the ground that it is violating the basic structure. Okay. In this, all various provisions were questioned, and Supreme Court said that it is not violative of the basic structure, because it is in a way trying to protect democracy. When you are saying, see, multi-party, it was argued that multi-party democracy is the core of basic structure of our constitution, and in the multi-party democracy, out of the free will, the MPs or MLAs should be allowed to change their political party. When you are restricting their choice, you are going against the democracy. So, but Supreme Court accepted this argument that defection is not in the interest of democracy. So, since this act is aimed to protect democracy, we cannot say that it is subverting democracy. Then the next argument was made against the office of a speaker, that presiding officer should not have should not be a adjudicatory authority. It was said, it was argued that this is a function which should be given to judiciary. Ultimately, it is impacting the independence of the judiciary. Here also, the Supreme Court said that that's not true. The presiding officer functions as a tribunal. So definitely, other than judiciary, also there could be some authority, there could be some quasi-judicial body, there could be some tribunals who can act as adjudicating bodies. Okay. Then Supreme Court, there was another provision which said in this 10th schedule that the decision given by presiding officer shall be final. It cannot be questioned in a court of law. Supreme Court said that this provision is unconstitutional, because it is taking away the judicial review power of the Supreme Court. So, Supreme Court said that his decision was subject to judicial review on the grounds of malafide, perversity, etc. So, if there is a grave violation of law or principle of natural justice or rule of law, in that case, Supreme Court can review and change the decision taken by a speaker. Okay. So you should also remember the name Kyoto Holohan case 1993, in which the whole of the 10th schedule was questioned. Supreme Court said that the whole of the 10th schedule is not unconstitutional. Only provision where the decision of presiding officer was made final, that part was declared unconstitutional. And Supreme Court said the decision of presiding officer is subject to judicial review. Is it clear? Any doubt till here? Now we shall move to the next part where we shall be discussing the issues with anti-defection law. So what are the issues? Can you help me here? You must have studied, this is something which is always in the news. In one state or another, there is always a case of defection which is happening, and there is always a office of a speaker which is under question. To be a speaker is the most difficult thing. One thing is to be a speaker, next is to be governor. Okay, so one issue is that there is discretion. No, not at all discretion. See, clear cut provisioning is there in the 10th schedule that if certain person has done this, he would be declared disqualified. So as such, it is not discretionary. सर जुडिशियल रिव्यू वाला प्रोविजन सिर्फ एंटी डिफेक्शन लॉ में एप्लीकेबल होगा. सी दिस एक्ट, this judgment was with respect to anti defection law. Okay, as such judicial review is part of basic structure. This is applicable in all the cases, but probably you are asking questions with respect to money bill, that in case of money bill, still the decision taken by a speaker is final, because that is something which is written in original constitution. That is not something which has come through Constitution Amendment Act. So only a Constitution Amendment Act can be questioned on the ground of violating basic structure. Something which was there in the original Constitution cannot be declared null and void by Supreme Court. Okay, so that's why Supreme Court has still not gone against that provision. Or Manoj, if your context was different, you may ask. Second, now let's discuss about the issues with anti-defection law. See, the issues can be broadly categorized. There are a lot many issues. Okay. In other case, the decision of presiding officer is final, right? Yes, yes, yes. See, why this provision was done that it should be the presiding officer who should be deciding? Because there is something called separation of power. There are three organs of the government: legislature, executive, judiciary. The legislature should be able to function independent of judiciary and executive. So whoever is the member of legislature, it should be the legislature who shall be deciding that who is going to be the member of legislature, Lok Sabha, Rajya Sabha or Legislative Assembly. And that's why we shall also see the privileges, that they have been given privilege that no, for anything said and done on the floor of the house, no one shall be penalized in a court of law. Why? Because of the separation of power. The courts are not supposed to interfere in the functioning of the legislature. So that's why it was presumed that the who is subject to disqualification or not, it's something which should not go to the court. It is something which should remain within Lok Sabha or Rajya Sabha only. Okay. Now we shall come to what is the issues with anti-defection. So these issues we can study under three different categories. One is that there is something which was obviously problematic as a provision itself. The provision seems inconsistent on its own. The second is we can study that whatever was the provision, it was not applied properly. There are certain issues that has emerged because of its application. And the third we shall discuss about principles. In principle only, the act anti-defection is not sound. Okay. Here I will be teaching you in this order. First I will teach you provisions because it is easy to understand. Second I will teach you about application because this is something that you must have studied in the newspaper, etc. And then I will go to the principle because it is more theoretical in nature. In actual exam you have to write in reverse order. First you have to write principles, then application, then provision, because this is the most important aspect, the principle related aspect. UPSC has time and again asked question directly on principle itself. Now let's see, first thing first, what is the issues with respect to the provisions. The first thing that is there is that why you have given exception to merger. Probably what you are giving in the message is that wholesale defection is allowed, wholesale defection is allowed, but retail defection is not allowed. This is again illogical. Either defection is allowed or it is not allowed. Why this collaborative? Then the difference treatment of independent and nominated member. The independent member will be subject to disqualification immediately, but nominated member have been given a time period of 6 months. This differentiation is also illogical. Then it does not cover the coalition politics dynamics. For example, there are pre-poll coalitions. If some political party like the chief minister of my state, he keeps on changing sides. He contests election with party B and then he goes to join party C. And then again he leaves party C and come back to join B. So if he does all such things, it should also be covered under anti-defection law. So it does not cover if coalition partners change side. Next, it is also applicable only to legislative action. Any vote or anything said and done on the floor of the house, then only. But suppose someone is doing something malicious outside the parliament, state legislature. For example, this is a case in Delhi, like Swati Maliwal. She is member of Rajya Sabha from Aam Aadmi Party. She is hurling allegations against the party chief. She is tweeting a lot many things against her party, but still party cannot remove him, and or she is not subject to disqualification until unless she disobeys the whip. That is the only criteria. Okay. Then in case of merger, you can also write one more thing is there, when you are writing issues etc. or the answers, all everyone is aware of all these issues. So your answer will be a good answer only if you write good examples. So you must write some examples as well. For example, in case of merger in 2022, 8 out of 11 MLAs in Goa Congress, they defected. In recent time, Congress has been subject to defection a lot many number of times. So this is an example where wholesale defection is still taking place. Next is, a speaker is not a suitable person to do the adjudication. The first thing is that he is a party person. So there is a question on his neutrality. Apart from this, see, this is a legal question. And now that after Kyoto Holohan case, it is subject to judicial review, this legal question can be questioned in a court of law, but a speaker is not a legal person. He is not a judge, jury. He is just a common MP. He is a lawmaker. So because of his inability or lack of expertise in legal matter, he is not suitable to do adjudication. Then there has no time limit has been prescribed. Okay. Here you can give an example that in Manipur, a Congress MP, MLA, sorry, a Congress MLA became subject to disqualification in 2017, became minister also, and remained minister for 3 years, and he was not disqualified. So in 2017, he defected, became a minister. The speaker did not disqualify him. He remained minister for 3 years when Supreme Court took up this matter and disqualified him. So Supreme Court has to intervene and disqualify that MLA in Manipur. That's the example. So this is something that has been misused time and again by speakers. Let's take a question by Yogesh. Sir, split happened in Maharashtra, Shiv Sena. How was it justified? I will tell you. In the next slide, I am going to cover that as well. Next, we are going to see the things. What are the issues because of the way this act has been applied? And the problem is in the office of a speaker. The speaker has been a speaker in India are party person. Like if you simply switch on the proceedings of Lok Sabha any particular day, if you simply look at, I mean, I'm not a party person, a teacher is not supposed to be, but from a neutral point of view also, if you simply look at the conduct of the Lok Sabha speaker, you can say very simply that he is not acting in a neutral manner. If any MP or MLA, any MP from opposition makes anything partially which is like derogatory to the government, he will take a strong objection. And the way he ridicules the MPs, it is like very unparliamentary, you can say. He will simply scold them like a student. They are dignified MPs, honorable MPs, but something like that. Whereas, like when someone from the treasury benches would be speaking, he can speak anything. You have seen it. They are allowed to speak anything and everything. They are allowed to abuse, hurl abuses, and do all the things which they are not supposed to do. So obviously, speakers, this is not something that you are going to write. This is just for the understanding purposes. Okay, and this is something which is very much accepted. You need not even need to give any uh, substantiation, or if you have to give substantiation, we will give in terms of the anti-defection law. It's only, for example, in Karnataka in 2019, there were around 17 MLAs of JDS and Congress who have switched side, who have defected, but a speaker did not take any action. Okay, so speakers have been acting in biased manner for quite some time, and this is an open secret now. Now let's take up the case of split within the Shiv Sena and the NCP political parties. This is also a classic case of what's wrong with this office of a speaker, or how speakers are being biased. First of all, see, if the political party, there was a political party which has got split. Now the 91st Amendment Act says that a split is not going to be a criteria, going to be an exemptions. So if both, there are two factions that has emerged in both these political parties, NCP as well as Shiv Sena. If you are recognizing one faction as the original political party, then the other faction must be disqualified, because it is not allowed to form as two different political parties under this anti-defection law. But the judgment given by the speaker said that there has neither been any split, there has neither been any merger. The both faction claims itself to be the original party, and a speaker termed it as intra-party dissent and didn't disqualify anyone. Either of the two sides must have been disqualified. We may not question whether which side was the original Shiv Sena, which should be given the symbols, etc. But either of the two must be subject to disqualification. The plain and simple reading says that plain and simple reading of the 10th schedule says that a split is no more allowed. Only merger is allowed, and in case of merger, you got to merge in another political party. You cannot form a new political party by merging. Okay, so this manifestly, this is contrary to the, and this is something which has been written in the Hindu, Indian Express, all the newspaper, they are writing editorials terming this judgment as this decision of a speaker as unconstitutional. Okay, so you can also write it as unconstitutional. The second thing is matter is in subsidies in Supreme Court. So till the time Supreme Court gives its judgment, we can give our own judgment. The third thing is as soon as Supreme Court gives its judgment, we will have to fall in line. We will not go against the judgment of Supreme Court. So suppose tomorrow Supreme Court says that no, speaker was right, then we will say it was right. But in my opinion, this is not going to happen. It was unconstitutional decision of the speaker. Yogesh is saying there should be a doctrine of once a speaker, always a speaker. Yes, yes, yes. It is not from USA, it is from UK. I will give you that suggestion. And then the defection is still occurring. Either you can take this example, but any example, any of the example, you should give any latest example of defection. And this defection is weakening the role of a smaller political party. See, larger political party who has 100 MPs, it is still relatively difficult to break their political party because of this 2/3 requirement. But suppose a political party has only 4 MLAs, then see, if out of 4, 3 MLAs join some other political party, it is 2/3. So, a smaller political parties are still feeling the threat of defection, whereas larger political parties are relatively safe, although I am using the word relatively because the examples I have taken, even Congress is not safe. So, the second biggest political party currently in the country is also not safe from this defection, but smaller parties are even more at risk. Okay. Then there is provision, there is problem on principle itself. In principle, it limits the freedom of a speech. Suppose, see, it is written in our constitution itself that there shall be freedom of speech and expression on the floor of the house. An MP or MLA should be allowed to speak his mind. It is not necessary that suppose there are 300 MPs like in BJP's, currently not 300, but more than 200 MPs are there. It will not happen that on any particular issue, all of them will have the same opinion. Like the 4 members of family do not have same opinion on many of the issues. Many of the issues they can have the same opinion, but on many of the issues they can have different opinion. But as per the anti-defection law, they are not supposed to have any different opinion. For example, on farm laws only, the MPs from Punjab and Haryana, they might have the different opinion, they might have a different standing against the opinion of the government, but they could not take that stand when the law came to vote in the parliament. Okay, so that's why we are saying that this is limiting the dissent, or rather intra-party dissent. Within the political party, you are not supposed to show or disagree with your head of the political party. In this process, what is happening? We are saying that the party loyalty is more important than the accountability towards people. See, these are the people who are representative of the political party, representative of the people. So they should be accountable to the people. They should take a stand or vote as per the wishes of the people of their constituency, not the wishes of their political party chairperson or political party president. Okay, so that's why in principle there is, it seems, undemocratic, and then it is breeding the centralizing tendency in political parties. In all political party, we are witnessing something called party supremo culture. There is one person who has become the party supremo. He is taking all the decisions on behalf of all the MPs and MLAs of his political party. The vibrant democracy, this is the way, the kind of democracy that we see in UK, where different MPs can have their own opinion. They bring their own private member bill. They have their own suggestions on a bill which is presented in the house. That is no more happening. So another thing, another drawback is, since you cannot take any stand contrary to the stand of the whip. So why would you do the hard work and understand the bill, understand the provisions, its pros, cons, etc. Because you know what stand you have to take. So there is a tendency among parliamentarians that they are becoming less involved, less engaged in the debate and discussion. So debate and discussions, the quality, or rather you can say the quality of debate and discussion has reduced in parliament. Now if you see, this is something that you might have observed it as well. If you open the debate and discussion on anything, if they are given 5-minute time, at least 4 minutes they will devote, or other first 2 minutes they will devote in praising their party president. Invariably, first they will rise on their seat and they will first praise their party president and other political leaders. They have given me the opportunity, blah 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 blah. Next 2 minutes they will criticize or do sarcasm on other political party which is not relevant to the point that is being discussed. Because in the past you have done something like this. I am not taking the name of the political party, but this is a common trend followed by MPs of all political party. I get disappointed as soon as I open TV. On a lot many issues, I open TV sometimes. Let's see what is being debated in our house. And after watching the debate, I got disappointed. What are the things they are saying? And then in last 1 minute or so, one or two provision, they will give superficial anything. They will quote something arbitrarily from here, there and everywhere. And they will finish their speech. Why? Because see, anyway, they have no choice. They cannot come up with their own research, etc., finding, etc. They cannot give any suggestions. So, what they are doing, easy way around. A score, play to the gallery. Say something which would be made a reel and which can be made popular, which will be circulated on the social media. Say something to praise your bosses. So that supremo culture is breeding because of the anti-defection law. Is it clear? Now let's move to the way forward and suggestion part. Suggestion, as Yogesh has already given one or two suggestions, Yogesh and Manoj. First, these are the suggestions that I would give. First suggestion is, you should limit the anti-defection law to certain cases where first a person voluntarily gives up membership, and voluntarily gives up membership should include only resignation and joining other political party. And then you should allow this or anti-defection disqualification only on vote of confidence or no confidence motion. On other bills, it should not be applied. So on other bills on which the stability of the government is not. So what was the purpose of this anti-defection? Because the governments were very frequently falling. Today, like party B might be having majority, few of its members will defect to C, and party C will have majority tomorrow, and the new government will come. So this was breeding instability to the government. So this stability or instability will come only on confidence motion, no confidence motion, maybe on money bill. So only on those bills or motion on because of which the stability of government is being questioned, the defection provision or disqualification provision should be applied, not on other cases. Second is that it should not be the presiding officer, rather president or governor which should be deciding, and they should be deciding it on the advice of election commission. This is the norm in other disqualification criteria, like we have seen the disqualification criteria for MPs, and in case they are subject to disqualification, it is done by decided by president on the advice of election commission. The advice of election commission is binding. Now election commission is first neutral body, and the second, it is an expert as well. So both the problem which was there with the office of speaker could be solved. The Supreme Court has given a different suggestion. Supreme Court says that it could be decided by we can have a permanent judicial body. Permanent judicial authority which can which could be composed of retired judges. So we can have a body or authority of retired judges which can decide on these disqualification proceedings. So as soon as a person becomes subject to disqualification, someone can complain to this judicial authority. This is also a good idea. So in this, again, new office would have to be created, a new institution has to be created. If this idea, nothing new has to be created. Okay, except for the fact that now we will have to talk about the neutrality of election commission also. We will discuss it in the topic of election and election commissions. Then we see that pre-poll electoral fronts should be treated as political parties. Okay, the people like Nitish Kumar should not be encouraged. They should also be discouraged from changing their political dynamics or changing their alliances. Then there should be okay, there were two other suggestions with respect to the office of a speaker that we shall discuss again later on. After this topic, we will be discussing the topic of presiding officer. There I will discuss those suggestions which you have mentioned in the comment section. And then the Law Commission has given this suggestion that political parties do not have this inner party democracy. The problem is here. Since there is no inner party democracy, because of which the MPs and MLAs are defecting from their parties, because arbitrarily sometimes they are given tickets, sometimes they are not given ticket. Arbitrarily, few are made ministers, few are not made ministers. So because of this arbitrariness, this defection incidents happen. So if we bring about the inner party democracy, it can sort out a lot many problems with Indian political parties. Okay. So there should be an executive committee in all political parties. It is already there. Most of the political parties have an executive committee, but this should have the responsibility to select candidates and conduct regular elections at every level. Okay. So this can solve the problem of defection. This again, this is a suggestion given by Dinesh Goswami committee. With this, we conclude this topic of anti-defection. There are two suggestions with respect to the office of presiding officer that I shall take in a little while. The next topic is presiding officer, but if you have any doubt till now, you may ask. Suman, you are already an IAS officer, as your name suggests. Why do you need a CSET book now? See, वैसे तो on serious note, there are lot many books, but one book of Arihant publication I found very good. So there are other books also which are equally good. I mean, in CSET I don't see much difference between various books, but there was one book of Arihant publication which I found really good. So that is something that you can follow. But even if you do the practice of all the previous year questions of CSET, that will also be very helpful, and that can also help you clear the CSET. CSET is more about practice. Next we shall see the topic of presiding officer. Now you please tell me, all of you who are online, what is the function of presiding officers in the house? Keep the presiding officer of Lok Sabha, Rajya Sabha both in mind when you answer it. What are the functions performed by presiding officers? One we have just discussed, disqualify the members in case of anti-defection law. What is there in Article 8081? To maintain the decorum of the house. Very good, very good. So to maintain the decorum will naturally include to suspend a member, to take disciplinary action against the members, and to run the house. So basically, the various functions. First is to maintain the order and decorum. Maintain the order and decorum, and it would include the power or the function to suspend or take disciplinary action if required, like more than 140 MPs were suspended during last Lok Sabha. Okay, and then they have to conduct the proceeding, and to conduct the proceeding would include to decide the business of the house. They will decide who will speak. They will decide who speaks, for how long. Whenever any motion or resolution is or rather any motion is moved, they will decide if it is to be discussed, debated or not. ठीक है? So they have the power to accept or reject a motion in case whether a need of voting is there or not. That is also to be decided. Need of voting, and voting has to be voice vote or what is the outcome of voting. All such decision is decided by a speaker or presiding officer. Then in case of Lok Sabha speaker, there are certain special function also which have been given. Anti-defection we can always written. Okay, disqualification under anti-defection. That is the first thing that we have already written. Then Lok Sabha, a speaker does something more. He decides about the money bill. He presides the joint sitting. Anything else? Any other function? The another point that you can write is he decides on point of order. Point of order is, say, suppose there are already Lok Sabha rules, there is constitution, etc. So suppose an MP comes and says that the rules of the Lok Sabha or rules of parliamentary proceedings is not being followed. That is called bringing point of order, that the order is not being followed. So who will decide if it is being followed or not? A speaker will decide. Or in case of Rajya Sabha, it would be decided by the Rajya Sabha presiding officer. And then the next case is this de facto makes a speaker the final interpreter of law in the house. Any law, whether it is constitution, whether it is rules of the house, everything, the final interpreter in the house is the presiding officer. And then he is also, when in whichever committee he is member, he is going to be the chairman of that committee. If he is a member of any committee, for example business advisory committee, so he is going to be the member of business advisory committee. He also nominates member to various political committees. There are few political member to parliamentary committees. There are few parliamentary committees in which members are nominated. There are few in which elected. So in case the members are nominated to a parliamentary committee, usually it happens in case of ad hoc committees. In ad hoc committees where members are nominated, the nomination is done by presiding officers. Okay. Oath is administered by normally by the pro tem speaker, but yes, you can say that is also the presiding officer. So that is also the function, administration of oath to the member, you can say. So a lot many functions we have written, administration of oath. Now see, these are all the functions. So one question can come, like there was once a question which was asked that what was the functions provided by the presiding officer, or like the functions of chairman, vice president as a chairman of Rajya Sabha. He also has to do all these functions except for this one, presiding the joint sitting and the money bill. So a lot many students were confused what to write, what not to write. See, whatever you have to write about the speaker, the same thing you have to write about the Rajya Sabha chairman also. Okay. The next thing is, then there a question could be that there is a need for presiding officers to be politically neutral. In that case, you will pick and choose those points where you have to decide or act as a what do you say, umpire kind of role. For example, when he has to act as a judge or umpire, in that role he has to be a neutral person. For example, when he is suspending or taking any disciplinary action, he cannot be biased, because see, more than 140 MPs were suspended and all of them belong to the opposition political parties. There was a case when Mahua Moitra was suspended or rather terminated from the Lok Sabha, whereas on the, I mean, probably one day with a difference of 1 or 2 days, there was another person who abused or who hurled communal abuse against other parliamentarian, and he was not subject to disqualification. So these biased behavior become important when you are taking disciplinary action, because here you are acting as a judge. And then, like when he is deciding who speaks for how long, opposition is always raising questions that we are not getting enough time. So the allocation of time among the members on speaking of any matters, this is something where his political neutrality is questioned. When he is accepting or rejecting a motion, when he is saying, sometimes he will always refer that you need to give at least 30 days advance notice, you need to give at least 15 days advance notice. But when government brings a bill, it is introduced without any notice. Sometimes people, like in case of Jammu and Kashmir reorganization bill, people have got information about a bill to be introduced in the house only at 11 a.m. in the morning. So sometimes there is no prior information, then also the government is allowed, but opposition members, for them a lot of rules are referred. So this is obviously they will question, they will not be happy. So all those points, like when in case of money bill also, money bill is something which will favor the government. When a speaker is acting, there is need for a speaker to be politically neutral. Yes, mic is also closed. These are the points that I have written. We have already discussed this point, because he regulates the business questions, motions, which question our supplementary questions to be asked, not asked, who will ask, and money bills, decide anti-defection petition, power to punish for breach of privileges, power to, see, when I teach polity, invariably a polity teacher is accused of being anti-government, anti-establishment. So by nature, see, whoever is in the government, anything wrong is to be done by that person only. Those who will have power only can do the misuse of power. And the constitution, while teaching constitution, we would have to be thinking a line of constitutionalism, where the power is limited or not. Okay, so as such, polity teacher is not against any political party. He is always against the people in the power, because invariably those who are in power, they will try to manipulate or maneuver against the spirit of constitution, try to increase their power. The limit which constitution imposes on their power, no one loves limit. If power is there to be enjoyed, okay, power is there to be misused. So that's why polity teacher is often considered anti-government. And at the same time, when I teach economy, many people often call me anti-business, because invariably when you teach economy, you will take example of Ambani and Adani. These are the cases which are happening. Our leader of opposition is accusing that when you are shaking hand with me, you are upright, you are an upright person, but when you are shaking hand with Prime Minister, you are bowing in front of him. And he is referring to the point that I have just told you, that speaker is the final interpreter of all the laws in the house. He is the topmost person in the house, so he should not be bowing down. We shall not go into this debate, but this is just to refer, or just to keep you in the memory, that there are very often debate around the office of a speaker. So what should we do? We should do what you have already suggested. We can have this convention of once a speaker, always a speaker. This is something which is followed in UK by convention. What happens in this? In this, what happens that once a person is elected to the office of a speaker, no one contests against that person in subsequent election. So suppose in 2019, if Om Birla became the speaker, if we have this convention that in 2024, no one shall contest against Om Birla in his constituency. And later on, after like Lok Sabha is reconstituted, whoever wins the election, the office of a speaker will go to the same person, Om Birla. So there is security of tenure. It provides a security of tenure. In fact, much more than the security of tenure. He is like lifelong going to be the speaker till the time he himself demits the office. He can himself decide that now I am old enough, I am not going to be the work of a speaker is taking a toll on my health, or whatever be the reason, and he can resign from his office, otherwise he will be a speaker. Okay. Now the benefit is that see, in the current case, what's happened? How do you remove the speaker? The process of removal of a speaker is very simple. By effective majority in Lok Sabha. What you have to do is simply through effective majority is majority of the then membership of the house, and which is always enjoyed by the prime minister, which is always enjoyed by the government. So a speaker, if does not toe the line of the prime minister, or he does not bow down in front of the prime minister can remove him on any particular day. He can bring about a motion or resolution to remove the speaker. So a speaker has to fall in line with the dictates of the prime minister. This is the problem with our office. He cannot be neutral. Under the current circumstance or current scheme of things in our constitution, a speaker's tenure is dependent on the government. So he cannot be anti-government. Okay. Obviously, here also there are problems like, I mean, this will give the problem that Yogesh is saying that absolute power will corrupt absolutely. So there can be a situation that a speaker can be like once a speaker, always a speaker, he can behave irrationally, but probably we can have the provision of impeachment of a speaker. So although the convention would be that once a speaker, always a speaker, no one will contest against him, his position is secured. Like the next time also after 5 years you have to contest election also in India currently. So suppose you go against the government, that party will not give you ticket to contest election next time. You will lose again. You will not be MP. So that's why currently it is the compulsion of a speaker to follow the government line, to favor the government. Lok Sabha speaker, even sorry, I just took the name of Lok Sabha speaker. I am taking the example of him only. But Rajya Sabha chairman, he is even much more biased. Okay, resign from party once appointed as speaker. UK convention. This is again the convention of the UK that he will resign from the party. This is something which was done in India also, like Neelam Sanjibba Reddy. He resigned from party when he became the speaker. This is also something, a practice which can be followed in our country also. So again, when you are resigning from your political party, it is again protected by the anti-defection law also. I mean, in anti-defection law, exemption is given, and the person can act as politically neutral. And this being political neutral will also improve the credibility in the office of a speaker. He will be respected by opposition benches alike. The opposition will also respect that office. And one suggestion which is there is that man of outstanding ability and impartiality to be chosen as a speaker. Okay, this was the some suggestion of Pandit Nehru, and this is another suggestions which is a quite common one and something different, can give you different flavor to your answer. Why don't we select an outsider as a speaker? Why can't we have a provision that an ex-CGI after retirement will be ex officio a speaker of the house? Like we have that vice president would be the ex officio chairman of the Rajya Sabha, we can have that after retirement the CGI would be ex officio becoming the chairman of, or other CGI or election commissioner, chief election commissioner. Those are the people who are outsider, who have the understanding of law also, and they can act in a politically neutral manner as well. So this is another very good suggestion that you can give, that let's broaden the umbrella from which we are choosing the speaker. Let's have an outsider to act as the speaker of the house. This will probably solve all the problems that we have in Lok Sabha. The opposition would also not be able to question the impartiality. Probably he will allocate times also in a rational manner. And he would be having the legal expertise also to take decisions on anti-defection law or any other like money bill, etc. Okay, is it clear? Now we have one last topic left, that is with respect to Legislative Council. If you have any doubt till now, please ask your doubt. Okay, so a state legislature, like we have seen in case of parliament, as the constitution writes that parliament consists of president, house of people and council of state. Similarly, a state legislature also is bicameral in India. Bicameral means there are two houses. There would be governor, legislative assembly, which is known as Vidhan Sabha or lower house, and then legislative council, which is known as Vidhan Parishad. This is mentioned in Article 168. But as we have seen earlier, not all states have two houses in their legislature. There are only 6 states as of now which has legislative council, and it is relatively easy. There is one cluster here, 4 states, and then there are 2 states in north. There are only 6 states which currently have. This is a factual question that can be asked in prelims. Andhra Pradesh, Telangana, Karnataka and Maharashtra, and then we have Uttar Pradesh and Bihar. Earlier Jammu Kashmir also had legislative council, but through the State Reorganization Act in 2019, the legislative council in Jammu Kashmir was removed. As of now, Bengal also has a proposal to bring about legislative council, but this is something which is pending with parliament. In case of Tamil Nadu, we have already made the constitution amendment. If you open the constitution, article 168, you will also see the name of a state, Tamil Nadu, where there is a state legislative council, but it has not been brought into effect. So constitution amendment is done, but it has not been made effective as of now. So the very fact that I am talking that probably Bengal is also trying to bring about this, Tamil Nadu had earlier, then it was abolished. Even West Bengal also had legislative council earlier, but then it was abolished. In Jammu Kashmir it has been abolished. It means that there has to be some procedure to bring about the legislative council or remove the legislative council. Yes, so there is such procedure which is mentioned in article 169. In 168 it is saying that there is going to be 2 houses in few states. 169 says that second house can be created or abolished using this procedure. What is the procedure? So the procedure starts in a state legislative assembly. A state legislative assembly has to be there. Okay, here a resolution has to be passed with a special majority, and this special majority is same which is there in article 368, which says that there has to be 2/3 of present and voting and majority of total strength. Both condition has to be fulfilled. So first of all, a resolution has to be passed with a special majority in a state legislative assembly. The state in which you are trying to create, for example, if you are trying to create it in Odisha, then in Odisha legislative assembly you will pass this resolution. Then the matter would be sent to the parliament. In parliament, in both the houses, the resolution would be passed with simple majority. Now this is something that in constitution amendment chapter we have seen, that if you have to bring about a legislative council, that constitution amendment can be done using simple majority. We have seen that some amendment are done using simple majority, And one of you had also asked this question, where is it written? So this provision is mentioned in Article 169 only. And 169 mentions that it would not be considered as a constitution amendment under Article 368. So you do not require a special majority, you require only simple majority. After that, notification is issued by the government. Then through this notification, SLC is created. Now, in case of Tamil Nadu, this notification is not issued. Till this, the process is complete. In constitution, the word has been replaced, but this step is pending. Okay, because this is ultimately a political process. Sometimes it so happens that one political party favors the state legislative council, it passes resolution, it goes to the parliament. By the time parliament completes its process, the political party is changed in the state. Now the new political party is not willing to bring about that a state legislative council. So because of that reason, the notification is delayed. Okay, maybe in the meantime resolution will be passed to abolish the legislative council. So it so happens. For abolition also the same process is followed. If a abolition is to be done, it would start in a state legislative assembly, go to the parliament, and same process has to be followed. Yeah, here the government means union government. So this is another example we have seen of centralizing tendency in our constitution. Although the process starts here, the second thing is that this resolution is not binding on parliament. Parliament may agree or may not agree with the resolution of the state legislative assembly. So ultimately it is the parliament who is deciding if a state will have legislative council or not. Is it clear? Any doubt? Oh, okay, I will ask a question, another question if you do not have the doubt. Suppose I have to abolish the state legislative council. Maybe in Bihar you want to abolish the state legislative council. You will pass the resolution with the special majority. Will that resolution be passed in a state legislative assembly only or both state legislative assembly and legislative council? For evolution, if you are abolishing, it means you already have a state legislative council. So whether you will pass resolution only in assembly or in both houses. Yogesh is saying only in council. Anyone else with any different opinion? Yes, Manoj, you are right. It is SLA only. Legislative Council has no role to play. You may write it down. Legislative Council has no role to play in its abolition. Obviously, there cannot be any role in its constitution because when something is not existing, how can it play any role? So either in its creation or in its abolition, the council has no role to play. In case of Odisha, what happened that Odisha government sent a special resolution that in Odisha also the legislative council should be created. The parliament did not agree to that. It is pending with the parliament. Parliament has not approved it. So parliament is not bound by the resolution of the state legislative assembly. Okay. Now we shall study another thing which can be also asked. Such factual questions are also asked sometimes. That is, what is the membership of a state legislative council? Suppose a state legislative council is created. What is the membership? How are members elected or nominated? Yes, Manoj, you are right. That is the second topic, which is the last item of our agenda. The criticism of SLC, or yes, a state legislative council. So, what is the membership? The first thing the constitution says that there has to be a minimum of 40 members. Very good. The second, this constitution says that the maximum strength cannot be, should be one third of a strength of a state legislative assembly. So the constitution mentions about the minimum and maximum strength of a state legislative council. Minimum is 40, maximum is one third of the strength. So suppose there are 300 MLA in the legislative assembly, maximum strength of legislative council could be 100, minimum is 40. So in between 40 and 100, the parliament will decide that how many members are going to be in a state legislative council. It also implicitly means that a small states cannot have a state legislative council. Suppose a state has only 90 members in its, or rather I will give you an example of, okay, suppose simple 90 members in its state legislative assembly. In that case, the constitution says that the maximum strength possible is 30, one third of the strength of legislative assembly. Maximum there could be 30, minimum 40, there is no number. There is no number which is larger than 40 and a smaller than 30. Is there any number which is larger than 40 and smaller than 30? So, a state whose legislative assembly strength is 120 or less cannot have two houses. Write it down, you may write it down, that a state whose legislative assembly strength is 120 or less cannot have, or sorry, is less than 120, not 120 or less, is less than 120 or rather 119, because there is a peculiar case of Telangana also, which has 119 member and they have taken the round figure. They have 40 member state legislative council. Okay. So probably if we are going by that round figure arrangement, it should be 118 or less. So a state having less than 118 members in its state legislative assembly cannot have both the houses. Okay. Next is that what is going to be the composition. In composition, first one third would be going to be elected by a state legislative assembly. Second, one third would be elected by local bodies. So two-thirds are elected. First, what you will do, you will divide this whole circle into three parts. First, one third would be elected by legislative assembly member. Second, one third would be elected by local bodies. Then the remaining one third you will do further two part. One part is that one third is divided by two parts, so 1/6 that is nominated by governor. Whereas in the remaining 1/6 part you will further do two part. So 1/12 would be graduate constituency elected by the graduates and another 1/12 is teacher constituency. Okay. So see, this is the only place in our Indian democratic system where you are at an advantage with respect to vis-a-vis any other illiterate person. Otherwise, the value of your vote is same as the value of the vote of any illiterate person on the street. But if you are graduate, you will get an opportunity to vote in this graduate constituency, whereas those people who are illiterate or who are only 10th pass or who are 12th fail, they cannot vote in this exam. Sorry, vote in this election. Okay. This is very important. I expect, if not in mains, in prelims, sometimes this question is going to be asked. This is due to be asked. I hope you have taken note. If yes, please let me know. Hmm. So teacher should be in a state government teacher. No, actually an electoral roll is prepared and they include the teacher of various recognized institute, and then the teacher of like university professor etc. They also get the opportunity. So it is decided by the, I would rather say, the council act only, that what all institutions are to be recognized, and some non-government institutions are also included. Okay, like those who are educational institution, their teachers are also included, but they do not usually include the coaching institute teachers, because these are the private for profit institutions. Otherwise the school etc., they are recognized as not for profit educational institutions. Okay, so normally the coaching institution, their teachers are not included, but some educational institutions which are not government, non-government, they are some they are also allowed, their teachers are also allowed. Now the next question, this is our last agenda of the class, is a state legislative council a secondary chamber? Is it second chamber or a secondary chamber? Now here, unlike Rajya Sabha, in Rajya Sabha we have said that it is second chamber. It is not a secondary chamber. You have to take a stand here that it's a secondary chamber. It is not equivalent to the state legislative assembly. And the major point of contention here, how it is not equivalent, is in case of legislative business only. Okay, so like all those points which we have written in case of Rajya Sabha, okay, that you can write. For example, in Rajya Sabha we have written that it is elected by indirect election or nominated. That is valid here also. So all those criticism, we have seen that those who do not win the Lok Sabha election, they are allowed, like political favoritism is done in case of distribution. The same happens here also. You nominate those people, or like they are elected, they are voted by the MLAs etc. So all those criticism which are there for Rajya Sabha, the same is for here, with one important factor, that is in case of legislation like in money bill, here also it is secondary. It cannot reject the money bill. It has to decide within 14 days what recommendation suggestion it has to give, and that suggestion is not binding on legislative assembly. In case of ordinary bill also it is secondary. In case of ordinary bill also it cannot reject. It can only delay it for 4 months. Only delay it for 4 months. 3 months in first instance and 1 month in second instance. So suppose what happens that an ordinary bill is passed by a state legislative assembly, it will go to legislative council. The legislative council will have 3 months time period within which it has to give recommendation or suggestions on it. It cannot reject any bill within 3 months. If it does not give its suggestion or recommendation, then the bill would again go back to the state legislative assembly. If a state legislative assembly again passes it, then it will have 1 month time period to give its suggestion or recommendation. If it does not give its suggestion or recommendation, then it would be considered passed in the format in which it was passed by the state legislative assembly. So it cannot reject a ordinary bill either. In fact, there is no provision of joint sitting. There is no provision of joint sitting in a state legislature because there is primacy of a state legislative assembly. Then the other things that we have seen that, see, money bill, ordinary bill, and then there was constitution amendment bill. In case of states, there is no constitution amendment. In case of Rajya Sabha, we have seen that there are certain special power with Rajya Sabha, like when a state has to enact law, when parliament has to enact law for a state list, article 249, there is no such provision here. When all India services has to be created, there is no such provision here. So those special powers which are there with Rajya Sabha, there is no such a special power with a state legislative council. A state legislative council does not approve any, say, emergency, etc., because no such provision is there. Neither financial emergency, a state emergency, nor national emergency. So since a state does not have any such function, here also a state legislative assembly do not, state legislative council do not perform any such function. Okay, so that's why we are saying that the most important function which is performed by legislative assembly is the function that they do the representation. Like they cannot pass the confidence motion or no confidence motion. The government is responsible to only a state legislative assembly. So all these things which are there, it is here also. So the criticism of Rajya Sabha is applicable here, but the defense of Rajya Sabha is not applicable here. That's why we are saying that it is a secondary chamber. Then the question arises, why do we have it? So the very fact that we have it is that we would have to defend it. Since it is in our constitution and we are appearing for the Indian civil services, we got to defend it. So you will say that it gives a second opinion. Its defense. Defense it gives a second opinion on legislative matters. And it can act as a review mechanism for hasty legislation. So sometimes it happens now that because of a particular event there is a knee-jerk reaction, something wrong had happened, and then all of a sudden a wave is flowing, and a politician trying to score the point, they may bring about a law. So such hasty legislation, if it is irrational, then it can act as a review mechanism. It can act as a deliberative body. It can act as a deliberative forum. See, the constitution does not envisage legislative council as a decisive forum where decision is made. It only envisages it as a deliberative forum, and that's why it has a very varied representation. Or rather, it has a very diverse representation. It has representation from teacher constituency, it has representation from graduate constituency, it has representation from local bodies, from MLAs. Okay. Then there are nominated members. So it has diverse representation where a more enriched deliberation or debate could take place. That is the role that it has to play, and this role become more significant in a say larger state where there is more diversity. A state where there is more diversity, for example, if you take the example of Madhya Pradesh, it is a lot of diversity. Some areas are very plain, some areas have high rainfall, some areas have low rainfall, some areas are kind of forest, some area kind of very dry land. So it has a lot of diversity. So it becomes relevant in large state. So we should have legislative council only in larger states, not in the smaller states. So the states having a lot of diversity, a state which is larger in size, is there is a requirement of diverse representation, more deliberation on any issues, and there only we should have these second house, state legislative council. The kind of system that we are having, we should continue with that. Is it clear? Are you convinced with the stand? Or if you have any doubt, please ask. Here you can also add one more point. Let's see. Its existence depend on a state legislative council. Sorry, a state legislative assembly. So we are saying that a state legislative council is inferior. Why? Because see, your existence depends on legislative assembly. Legislative assembly can pass a resolution to remove the legislative council itself. So you are definitely secondary to legislative assembly. Legislative assembly is primary. Yes, that is true. Manoj is asking that can a bill be introduced in either house of the state legislature? That's true. Here it has parity with Rajya Sabha, that a bill can be introduced in legislative council as well as legislative assembly. Okay. So that's all that we had. In next class, we are going to discuss about the functioning of the parliament, how the quality of debate etc. is going down in the parliament, what are the improvement reforms that we should bring about the in parliament. If you want to follow me, you can follow me in any of my social media handles, and let's meet again tomorrow. I would hope that all these basics things, like, and also parliamentary committee we are going to cover tomorrow. So I would request you to go read the parliamentary committee chapters, some of the parliamentary committee, because those factual things I am not going to cover. I will only going to cover the analytical things in tomorrow's lecture. So I would expect you to go read the Lakshmikant, study those parliamentary committee related things, and then come attend the tomorrow's lecture. Okay, so see you again tomorrow, 2 p.m. Take care.